Good afternoon, everyone. My name is Lynn Wilson. I'm the Business Development Specialist for the IDRS ACORN project, and I just want to welcome everyone to the webinar, Contract Disruption During a Crisis. Just to tell you a little bit about the ACORN project, we partner with tribes and Native organizations to provide training and technical assistance to tribal members who are interested in starting a small business. And we primarily serve tribes throughout California, Nevada, Oklahoma, and on the Navajo Reservation in Arizona. Most of our services are provided through grants from USDA Rural Development and the California Governor's Office of Economic Development. So we just really want to give a thank you to those organizations for helping us fulfill our mission to improve reservation economies. We are recording today's webinar, and it will be made available on our website within a couple weeks, and I'll make sure and notify everyone when that is ready. And I will also be emailing the PowerPoints to everyone after the webinar today. So during the webinar, if you happen to have any questions, you're welcome to go ahead and type those in to the Q&A section. We're not going to stop Mr. Gonzales for questions actually during the webinar, so we'll take anyone's questions at the end, but you're welcome to go ahead and type those in. So at this time, I just want to welcome Mr. Bennie Gonzales. He is a government contracting expert, and he owns Supplier University, which is a platform that offers online courses for anyone that wants to learn more about the acquisition process. So at this time, I'm going to turn it over to Mr. Gonzales so he can introduce himself and let you know what he's going to cover in today's webinar.
Okay, thank you, Lynn. I'd like to start off by thanking Lynn because she's done a lot of work to try to get these webinars on for you. And we've got a lot of stuff to cover, folks, so let me just kind of introduce myself, give you a little bit of information about myself, and we'll get started. I've actually been working with the federal acquisition system for well over 40 years. You know, I started when I was about 10, I think, right? You can believe that. And the last 14 years, I've been working in instructing the federal acquisition workforce, the contracting officers and contracting officer representatives. And so, yeah, I teach the COs and the cores how to do their job. And so, you know, I've really enjoyed that the last 14 years, and I'm going to continue to do it. And a lot of them are going to be doing just like this. So before that, I worked for the Department of Energy's Los Alamos National Laboratory. Now, Los Alamos National Laboratory, and I'm pointing that way because it's actually located about 35 miles from where I live. I live in Santa Fe, New Mexico. And so I retired out of Los Alamos. Before that, I worked in Alamogordo at Halban Air Force Base, and then later on, I worked at Nellis Air Force Base in Las Vegas, Nevada. And so, you know, as a CO, so during all this time, I've been a contracting officer. I've actually placed and administered supply contracts, construction, service contracts, R&D, and I've placed all types of fixed price contracts, a whole family of fixed price contracts and cost reimbursement. So I tell folks that I'm very blessed in having gone. I look back and I said, wow, you know, what a ride, you know, great institutions that I worked for. And today I really want to share a lot of that information, especially now because of this COVID-19 and the issues that we're having and wanting to help you, the small businesses. So again, thank you, Lynn, and the ACORN project for making this possible. So what are we going to be talking about today? What we're going to be talking about is, in a nutshell, in the event that the government basically terminates, or one of the things that they could possibly do is terminate your contract for convenience, or if they stop it for some reason or suspend it for some reason, what are their responsibilities and what are your responsibilities? What can the contracting people do and what shouldn't they not do? And if you're affected and you submit a proposal to the government to basically make you whole, what is that process? and basically, you know, how can you recover if you are experiencing some losses during the time that you have a contract with the government. So we'll be talking about all of those things. But first of all, I want to kind of set the groundwork. So the pie chart that you see here is basically communicating to you that when the government basically issues a solicitation, it's got three parts. You've got if you notice there, you've got the work statement, clauses, and provisions. And then what happens is that when the contract is awarded, you've got the work statement or specs and the clauses, and then and so that's what you got left. But today we're going to be talking only about the clauses, and we're going to give you three examples of contract types that are set up there, and we're going to be talking about the clauses that are within these contract types, especially those contract clauses that can affect the stoppage of the work, suspension, or termination of the work. Now, before I get started, I got 8 very important points I want to make to you as ground rules. So it's something that's going to pertain to this entire webinar. And so let me start off by saying that to be binding and legal, any suspension or terminations of any of this work or stop work has to be formalized, and it has to be formalized on this form that you see in your PowerPoint right now. That's called the Standard Form 30 Amendment of Solicitation Modification of Contract. Now, we're going to talk about amendments. We're going to talk about modifications to your contract. So if you've got a contract with the government, any changes that are going to be made have to be formalized here. And it's very important that you pay attention to what can and cannot be done, and effectively how it's done on this form. Now, if you look over on the form, I've got a big circle around a block 13, because that's where it's going to be very important for you to understand what happens, what has to be marked, and why the information that's in that block is important. Down at the bottom, you've got 2 circles, a green one and a red one. The green one is where you're going to sign off on and to agree on these modifications when you can agree on them. And the red one is where the contracting officer signs off on. Now, when both of you sign off on these, it's called a bilateral agreement. In other words, the modification is a bilateral modification. When the contracting officer signs off on it alone, it's unilateral, because I'm going to be using those terms. Unilateral meaning just the CO, bilateral, both of you are going to sign off on, okay? So kind of remember that. Another important ground rule is, folks, do not take any action unless it comes from the contracting officer. The core contracting officer representative or the program managers or other people may be telling you, hey, you need to be doing this, blah, 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 and you know it's affecting us in this way, you're going to have to do that. Let me tell you, folks, at this time, do not follow any of the guidance they give you. Get a hold of the contracting officer, let them know that somebody else is giving you this direction or wanting to give you the direction, and ask for guidance from the CO, because the CO is the only one that has authority to make a change. Now, that leads me to ground rule number 3. The contracting officer, when they make a modification, remember that little form that I just showed you just a second ago? They have to state the authority. And I'm going to be talking about that, where these authorities are stated. And the authority lies within the contract clauses. They just can't pull anything out of thin air and say, hey, this is what we're going to do. You know, that we want you to do that. No, it's that authority has got to be within those particular clauses. So when they make a change, and if you notice here, I'm showing you 4 little arrows that point to that block 13 that I showed you just a second ago. Look at the term, it's all authorities. It's basically saying, yeah, when you block that little block to the left, you've got to state what authority is. Now, I've moved back a little bit on that form and I've circled it there on that form. One of those blocks is going to have to be checked off when a change is made, and we're going to go over that. So, and the reason is that I want to emphasize that is because, again, the contracting officers just can't do what they want to do and they've got to have an authority, and they've got to block the correct form of the correct block there. Now, if you notice, I've also got block 14 circled because that's where a description of the change is going to be made. And I'm going to be talking to you about that, how important and critical it is that that is very clear, because that's where the legal, you enter into that agreement, and that makes it legal, okay? Now, another ground rule is some of the clauses, and I'm going to show you 3 examples, okay? In 2 of those, the contracting officer can issue a directed change, and 1 of them they cannot, and I'm going to talk about those here just in a minute. But when a contracting officer issues a directed change, and they have to have the authority to do that, and that clause has got to be in your contract. If it's not there, the contracting officer cannot do it. All right. So in this case where they can do it, unilateral means that only the contracting officer is going to sign off on that Form 30. But like I said, authority to do so is not found in all of these 3 examples, and I'll show you which ones again. Now, the suspension of work, and this is ground rule number 5, that the suspension of work or stop work can be unilateral. But again, the authority to do that has got to be in the form of a contract, a clause. Now, one of those examples that I'm going to show you does not have a stop work or a suspension of work, and I'm going to show you that again here just in a minute. Another couple of things that I want you to remember is these clauses that we're going to be talking about talk about in the end, if for instance, the contracting officer suspends or stops the work, the language there is very important as to what the settlement is going to be. And there's 2 terms that I want you to remember as you look at these clauses: equitable adjustment or adjustment. The term equitable adjustment infers that once the negotiation is made, in other words, you submit a proposal to the government and you go to a Form 30 and the negotiation is agreed upon, okay? If that contract clause basically stated that there would be an equitable adjustment, you're permitted to get profit on that. Whereas if the contract clause states adjustment, you're not going to get any profit on that. And that's important because a lot of the firms that I've dealt with in the past, and let me tell you, I've dealt with them using all of these clauses. Oftentimes we get into a lot of this type of stuff because they want to make profit on some of the work that they've done or expected to do. So we'll talk more about that. Now, another thing is the contracting officer cannot add new FAR clauses unless you agree. In any of these 3 examples I'm going to show you, okay? In other words, the contracting officer can basically says, oh, we're going to do this, or I'm going to add this clause, or I'm going to change this FAR clause. They cannot do that. Now, I'm going to back that up by showing you here, where does that come from? Well, if you look there, it's FAR 1.108D. And basically, let's kind of read that subparagraph D of that particular provision, and it's in the FAR, Federal Acquisition Regulation. And you can always go in there and just basically put this little FAR clause on in Google and it'll bring it up for you. Look what it says: application of FAR changes to solicitations and contracts. We're not going to talk about solicitation, we're going to talk about contracts. And this is guidance to the contracting officer. Please remember that. And this is a provision in the Federal Acquisition Regulation giving guidance to the contracting officers. And it says, hey, contracting officers, unless otherwise specified, and let's kind of go down to number 3 there. It says, hey, contracting officer, you can, at your discretion, basically include the changes, and they're referring now to FAR, okay? Either a change or actually also an addition, a clause addition to your contract, because that may happen. Include the changes in any existing contract But look what it says after that, with appropriate consideration, which means you have to agree to it. So pay attention to me here, okay? They cannot, under no circumstances, add a new clause. They can't unless you agree to that and you get consideration. Now, what's consideration is, if it affects you monetarily, then basically they're going to have to fess up and basically change the contract value. It may not affect you monetarily. Then basically there's not going to be any additional funds to your contract. But they cannot do it unilaterally. They cannot just say, I'm going to stick this in there and sign off on it and send it to you. Can't do that, okay? Now, last thing I want you to understand is, got to read your contract. What does it say? Now, I'm going to be talking to you about these 3 different sample contracts and the contract clauses that are behind them. And these are the 3 that I'm going to be talking about. The forms, you notice each of them has a little bit different form, okay? Now, in every contract that's let, okay, except one, and we're not going to be talking about that right now, there is a form in front of it, okay? And you sign off on these particular forms. And we're going to be talking about Form 1449, Standard Form 1442, and 33. And I'm going to be describing each of those here, okay? So let's start with a 1449 solicitation contract order for commercial service, commercial items and services. Now, and services is highlighted because that's not in the title. And you may say, well, Benny, you're saying it's for services, but why isn't it a title? I'm going to tell you, I don't know, okay, except that the definition, if you look at the definition of commercial items, it says and services. So that's going to get changed. In fact, it's going to get changed. There's a change that I just read about here a couple of months ago, where they're going in and changing the definition of commercial items and commercial services. Basically, it's not going to be a major change, but they will separate it rather than include services in the term commercial items. But anyway, so if you get this particular type, this 1449, okay, this is one of the most commonly used form, and it's used to purchase items and services and also construction. Now, usually agencies out there do not use this form to procure construction, but because they're permitted to do so using this particular method, more and more agencies are beginning to do that. But it's got to be construction under this simplified acquisition threshold, which is $250,000. Now, why is the government doing this? Why are they doing this? Because the 3 that I just showed you, let me kind of go back, okay? These 3, if you notice the one on the left, which is the 1449, and I've got the 42 and 33, those latter 2 have been in use for decades, you know, probably 70, 80 years, whereas this particular form came up just in the mid-90s. And it's to really simplify it for you and the government, okay? And one of the key things I want you to look at, and why this particular method is different and has different clauses, is because the government was trying to simplify it. And the clauses are changed, they're shorter, they're simpler, less complicated, not as rigid, and more like industry is doing business. That's really the whole thrust of it, is the government wanted the government acquisition workforce to buy stuff more like industry does that, okay? Now, if you have one of these contracts, you want to pay attention to Section C. So if you open up your contract, you go to Section C, you're going to have these canned clauses, okay? These canned clauses, and there's going to be 2 of them. Now, the government can add additional clauses, but usually what you're going to see are these 2. And that's the good news. So, Benny, there's only 2 clauses? Yeah, it's a good news, but you know what? Look at the subordinate statement that I made in there. The first one has 22 subordinate clauses, and the next one, -5 there, has what, 120. So it may not be as simple as what the government wants to make it, but that it is what it is. Now, we're going to be talking about this one particular clause, which is 52.212-4, Now, as I mentioned, there's 22 subordinate clauses. So if you notice up there, these particular clauses here are A through V. Now, we're going to only be talking about these four here. The changes clause, disputes, excusable delays, and termination for the government's convenience. We're only going to be discussing those because those are going to be some of the changes that may come into play if your contract's got to be suspended or there's going to be stop work and things of that nature. Now, what's important to understand, because again, we're looking at this 1449 commercial items or services, okay? There are no stop or suspension clauses. They are not, but you've got the closest thing there is going to be that excusable delay thing. Sorry, excusable delay clause. So what's going to happen, all changes are going to have to be negotiated. That's one thing you've got to remember. I'm going to show you why here in about 10 seconds. And then the contracting officer has no unilateral authority to order you to stop or suspend work. Oh, really? Wow, why? Well, let me show you this. That changes clause is in there. Remember, which is this little puppy here. Okay, C, that little changes clause. This is what it says. It's 19 words, folks, and it says changes in the terms and conditions of this contract. Your contract, this one right here, 1449, may be made only by written agreement of the parties. Only by written agreement of the parties. That's not the case in these other two that I'm going to share with you. And what does that clause mean? And what does it state? The contracting officer cannot issue directed or unilateral changes in the work being performed. They just can't do it. You must agree to all the changes in there. In other words, you've got to sign off on that standard form 1449. Bilateral agreements could be stop or suspend work. What do I mean by that? Well, I told you that these clauses aren't in there, but if the government wants to put that in there, in other words, they want to tell you to stop work or they want you to suspend work, they can do that, but it's got to be unilateral. You've got to sign off on it. I'm going to show you how that's done here in just a few minutes, okay? Give you more details on that, okay? Now, let me say one other thing. I said here that the CO cannot issue directed or unilateral changes. There is a couple of exceptions, and I'll talk a little bit about those because they're kind of unique, okay? But generally, they can't make any changes unless you agree to it. So if they use a changes clause, you're looking at the changes clause. Let's imagine that they want to stop work or suspend work, and they want to use the changes clause as authority. You notice what's happened there. It says this supplemental agreement, which means it's bilateral. This is another word for bilateral. Both of you got to sign off on that particular standard form 30, and you see the block where it's supposed to be blocked. The authority, what's the authority? The changes clause. Because the changes clause, 19 work, says, hey, you can make changes, contracting officer, but it's got to be by agreement. Both of you got to sign off on it. Now, the thing that you've got to pay attention to, folks, is this block 14. Let me tell you, this is so important. If you agree on whatever it is that you're going to agree, and this pertains to any of my discussions on any of the other clauses, when you sign off on this form, make sure that there's a description in that 14 that's very clear of the changes, especially in this particular case where the government wants to stop or suspend the work. They've got to put in here what's going to be the new date for you to start the work, if they're going to suspend it or stop it. Now, or it could be an estimate. It may not have to be a precise date, but could be an estimate. It also has to give you directions when you're dealing with this particular type with a 1449. The contracting officer's got to give you directions. What does the stop work mean? What do you mean, contracting officer? You want me to stop the work? They can stop all of it or suspend all of it, or they can stop part of it or suspend part of it. The contracting officer's got to give you this direction. It is imperative you get it. The other thing that you want to make sure is that the equitable adjustment language is in there. Remember, because you got to agree to it. This is a supplemental agreement. You both got to sign off. So make sure they're going to give you profit on the changes that on the stop work, because they're going to tell you here also, you're going to have to submit a proposal to them as to the effect of the stop or the suspend work. Now, this next PowerPoint, the same thing's going to happen. You're going to agree, a supplemental agreement on the modification once a negotiation settlement is reached. And here you have at block 14, the negotiated specifics, and you've got to pay attention. You submitted your proposal and you said this is the effect on it. Make sure all of those things are covered in that particular block 14, okay? And the main thing that you're going to be interested there is the contract value and the dates where you're going to have to begin the work again. Again, if the changes clause is used to stop or suspend the work. Now, let's talk about the disputes clause. Now, the three examples of clauses of contract types that I just showed you a while ago, okay, we talked about this one. All of these have the disputes clause. I'm going to talk about it once, okay, because the disputes clause is in all of them, the exact same clauses in there. Now, what I'm going to show you, this is what Standard Form 1449, 52212-4D states about the disputes. And the disputes clause are incorporated by reference. So what you're going to have to do, you're going to have to go into the Federal Acquisition Regulation, read that clause. Now I'm going to tell you basically what it says, okay, but you've got to read it. Basically says that the parties, excuse me, the parties cannot agree. In other words, you submit your proposal and you're knocking heads. You know, government doesn't want to accept your proposal in terms of starting up the work again because of the stop work or the suspension of work. The parties, basically, you're going to agree, yeah, if we can't agree, we're going to go to ADR, our alternative disputes resolution. I think a lot of you are probably familiar with that. If not, just Google it and you'll find out exactly what it is. But basically it says, we're not going to lawyer up. We're going to try to work this thing out. And the disputes clause basically says that the ADR is going to be with a contracting officer and possibly a third party. Now, one thing that the clause doesn't say that you've got to understand can happen is that you can take this ADR above the contracting officer. Yeah, to the contracting officer's boss or even higher. You can take the ADR to the small business specialist and they can help you resolve it with a contracting officer or to the ombudsperson. You can even take it to the head of the agency, okay? And again, the clause doesn't say that, but the processes behind that do permit that. If in case you want to take it to the agency, they've got to agree to that. Okay, so hopefully you can not lawyer up, deal ADR, settle it at the lowest level. If you cannot settle it with ADR, basically the contracting officer makes a final decision, says this is all we can give you. Okay, and then what will happen is you can appeal it. You can appeal it to either the board of contract appeals or the federal court, okay? And usually you have to go first to the board of contract appeals because they're going to wonder, hey, if you go to the federal, if you go to the federal court, the court's going to ask you, why did you not go to the board of contract appeals? But anyway, the other thing is this is a very powerful clause. Now look at the bottom bullet that I have there. It says contractor must continue performance regardless of dispute. So if you're like this, it doesn't make any difference. You know, the contracting officer says this is all I'm going to give you and continue the work, and you appeal it. And then I can't tell you what's going to happen, but I can recommend to you, try not to have to go to the board or the court. It's going to cost you a lot of money. You got to lawyer up. Try to settle at the lowest level. Okay. Now, excusable delays. If you look at this particular clause, it's 2 sentences, folks. It's a simple one, yeah. Because remember I told you, 1449 made it kind of simple. So this is just 2 sentences. But I've highlighted a couple of things there. That the excusable delays basically talks about acts of God, quarantine restrictions, okay, or delay of the common carrier. So let me jump in and tell you basically what the contract states, what it means. One of the things that you have to do is that you have to notify the contracting officer that there's an imminent delay, okay? Now, it could happen if the contracting officer tells you, hey, we're going to probably stop work, and basically the CO says there may be an excusable delay. What's going to be the effect? You have to let them know. Now, this is very important, folks, and this really pertains to a lot of the other clauses we're going to talk about. If you've got an imminent delay, or there's a problem or issue, you've got to send that and let the contracting officer know immediately. You've got to get a confirmation that they received it. So if you send an email, ask for a confirmation. Be specific in the details that are going to affect your business if you're using this particular clause. It must be factual. You can't make stuff up. You can't say, oh, it's going to affect me like this, and you have no basis for making that particular statement. And this is important because in the end, the contracting officer just is not going to take your word for it. They're going to verify it. They're going to want more information. So you got to be factual. You got to back it up, okay, with documents. And I've had contractors that have told me, oh, yeah, we were delayed because of this. And I said, show me the proof. And they couldn't come up with it because a lot of that stuff's made up. Don't make it up. It's got to be factual as best as you can, okay, because I know the situations may be a little tedious, a little difficult for you. But details are going to be important, especially once you submit a claim down the road. The contracting officer must advise you, give you direction, what they want you to do. So if you tell them, I got a problem, I'm going to get a delay, because of the coronavirus, my subs can't perform or something like that. Okay, the contracting officer's got to give you direction, what they want you to do. Do they want you to stop? Do they want you to suspend? They've got to work with you. So understand that they've got to do this. Now, the stop or suspension can be an email. This is important to remember. The stop or suspension can be an email from the CO, but it must be followed up with a modification, all right? Understand that contracting officer can tell you, yeah, we're going to accept excusable delays or whatever, but they've got to follow up with a modification. So what would the modification need to look like if the excusable delays clause was going to be enacted? Okay, so you see here the example. Now, again, we're looking at the 1449. They cannot make any directed changes, so you have to agree to it. And if you look here, it's going to be a supplemental agreement. In other words, it's going to be bilateral. Both of you got to sign off on it. Here's the authority, excusable delays. Now, again, I'm going to be pointing out to block 14, look at what has to be done. If it's going to be stop or suspension, what's going to be the new date for the startup? The contracting officer's got to give you directions here, including, hey, you're going to have to submit a proposal, and they're going to have to tell you what you have to put in that proposal, okay? And then the language that we talked about before, equitable adjustment, remember that? Make sure that's in there because you're going to agree to it because you want to get profit from that particular change. Now, once it's all said and done, once you submit your proposal, and let's assume that it's all agreed to and everything else, the same thing's going to happen. This is the blocks that they're going to mark, supplemental agreement, this is the authority. And what's now going to be very important in that block 14 is the negotiated specifics. What is the new performance period? What is going to be the end of the contract if they extend it? Could be unchanged. They may want you to accelerate the work, okay? And we'll talk about that here in a few minutes. But the contract value, what is going to be the contract value? Now, this could happen several months down the road, folks. I'm going to tell you that right now. The final settlement after you submit your proposal. It may not happen right away, okay? But so you may be on the hook for continue to perform the work until this settlement is finalized. Now let's go to the termination of government for the government's convenience. Now this is about 4 sentences. Okay, is it simple? Yeah. Now I've highlighted some things in there. It says contractors shall be paid a percentage of the contract price reflecting the percentage of the work performed. And so what does that mean, Benny? I'll tell you that in a minute here. And then it says the contractor shall not be required to comply with cost accounting standards. Now, what that means is basically these other here's my graphic here, okay? We're talking 1449. These other types we're going to be talking about deal with what's called cost accounting standards. This does not, okay? I'll talk to you about what that means in a minute. The contractor shall not be paid for any work performed or cost incurred which reasonably could have been avoided. So you can't stand on your thumbs there and just say, well, what I'm going to do, you know, you've got to, if you can reasonably avoid some costs, you're going to have to do that, okay? Now, what does the clause again state? The government again here, this particular clause can terminate the contract at any time. They don't have to explain. It could be all or part of the contract, all or part of the contract. So that has to be defined in those modifications. You basically are going to have to stop the work of your subs and your suppliers immediately. And the final cost settlement process is going to deal with a percentage of the work completed. Now, if you've got a supply contract and you ordered 25, or the government ordered, let's say 50 items, you deliver 25, that's pretty simple. That's 50% is what they're going to pay you. Now, for construction, if it's construction or if it's services, it's a little bit more difficult to really come up with the percentage. I'm going to make a recommendation to you that before you go off, you negotiate with a contracting officer and say, let's use this as the process. You've got to have the same process that you come up with what it's going to cost you and what the government basically has when they develop their negotiation objective with you, okay? Now, this is the way it's going to look like if they use a termination for convenience clause, if they're going to terminate part of your contract. It's got to be a this one is going to be unilateral. This is the one that I told you was going to be an exception. This is going to be unilateral. The contracting officer basically has that authority. And that authority is rested here in FAR 43103B. So basically, the contracting officer can terminate this for convenience because the clause allows them to do that, okay? So basically, they'll say, hey, we're going to terminate it, and here are the termination specifics they've got to tell you. Describe it for me. Is it all or part? And tell me, contracting officer, what type of proposal do you want me to provide to you? And then make sure, if you can, because this is going to be unilateral. In other words, they're going to sign off on it here. See if we can get that equitable adjustment language in there that we talked about. Now, after it's all said and done, after you submit your proposal, you come to an agreement. It's got to be a supplemental agreement. In other words, both of you are going to sign off. It's going to be bilateral. Here's the authority. Excuse me, the termination for convenience here. This is the important part, the details of the settlement, okay? Because they're going to be terminating part of that contract, and they're going to change the contract value basically from one figure to another. So you got to pay attention to that and negotiate hard, okay? Now, that's the 1449, which is commercial items or services. Now we're going to talk about one of these two, which is construction. So let's just jump into there. Now, Standard Form 1442 is called solicitation offer and awarded for construction, alteration, or repair. We're going to concentrate here just on the construction. Now, when you get into your contract, where are the clauses that you got to watch out for? Well, these two areas are in Section H or Section I. Now, we're going to concentrate on Section I. Section H are normally special clauses that the government puts in there that effectively speak to that particular either the construction that's being done. Okay, but so the one that we want to talk to you about are these contract clauses in I, and I've got them listed here for you. And we're going to be talking about the suspension of work, because again, let me tell you the difference between services and construction. The clause suspension of work is used for construction. Stop work is used for services, supplies, and R&D. We're going to talk about that here later, okay? So construction, you're going to have a suspension of work, changes, termination for convenience of the government. This is a short form of termination for convenience, usually for requirements under 250,000. Then we're going to talk about the long form of termination for convenience. Can also be used for, and this is actually greater for than 250,000. We're also going to talk about default and dispute. So let's go ahead and start talking about the first one, suspension of work. This is the entire clause. I'm not going to read it out for you, but I'm going to jump in and tell you what the clause states. It says the government can suspend, delay, or interrupt all or part of the work for an appropriate period. It's up to the government to figure out what that appropriate period is. It may be that they're going to have discussions with you for you guys can figure it out between both of you. If the suspension period is unreasonable, and what's unreasonable, that's really going to be a matter of judgment between you, actually from the contracting officer and you. There'll be a cost adjustment. Now look at the term adjustment. You're not going to get any profit there. What's reasonable is going to be based on facts, folks. Let me tell you again. I know I'm being redundant. Oftentimes they call me the Department of Redundancy Department because I keep repeating these things. But it's got to be factual, okay? If you submit your proposal, whatever those costs are, they got to be factual. You can't make them up, okay? And you just can't say, well, the delay's going to cost me this much. You're going to have to back it all up. The adjustment process, in other words, for them, from your proposal and the negotiations, you submit a claim, okay, and extension of the performance because they're just suspending the work. You're going to have to tell them, this is how much, this is the extension I think I'm going to need based on your direction. The government can either accept, negotiate, or reject your claim. If agreement is reached, again, you're not going to get any profit. But the standard form 30 is going to have to be signed by you. Okay, I'll show you the example here in a minute. And an agreement is not reached, you're going to go into disputes. You're going to lawyer up and do one of these things. So again, try to come to agreement here, okay? Now, if the suspension of work clause is being used, okay, for this particular work, for this particular suspension, it's going to be unilateral because they have the authority. Because understand, here it's very limited, but under these two types that I'm talking about, and talking about this one now, construction, it's allowed, but it's allowed again under 43103B that they can do this unilaterally. So they suspend the work, excuse me. They suspend the work, and what's important is this block 14. This is very critical again, folks. How long are they going to suspend it? What is the direction? Do they want you to terminate the subs? Do they want you to your suppliers? What do they want you to do? That direction is going to be very, very critical. Now, although it's a small block, the government can give you 3 or 4 different attachments with all the direction that they want you to go. So also the language is going to state that it's an adjustment. And again, you're not going to get any profit there. But understand, get the direction in writing in terms of what that suspension is going to be all about. Now, once it's all said and done, and it could be, like I said, 2 or 3 months down the road, you submit your proposal and you said, this is what it costs, you negotiated, and now it's a supplemental agreement. In other words, you've got to agree on it, okay? Both of you agree. The description of it changes, the new dates, right? The contract value, likely to be much more because I know that under suspension of work, it's not, especially when it's going to be a month or 2, it's going to take some money there on your part, and it's going to cost you, okay? So let's talk about changes fixed price. Now, remember I talked about under these three examples, there cannot be a change order here. But I did tell you that under these other two examples, now we're talking about construction, there can be a change order. It's a very powerful clause, and it says the CO may at any time without notice to the sureties. Who are the sureties? The sureties are your insurance companies, okay? If any, by written order designated or indicated to be a change order, make changes in the work within the general scope. And it's very important for you to look at this within the general scope of the contract. In these areas, these are the areas that they can make changes, and that's it. So let me tell you, folks, it's very critical. If they've used this as the authority, it's got to be one of those four areas where the change was. Now, because this is construction, look at the last one. It says directing acceleration in the performance of the work. Put it in here because of the fact that if there's a change, okay, the contracting officer could come in and after the suspension of work, they could come in and now direct you to accelerate the work, okay? And so that's going to be great for you, but then there's going to have to be an agreement, and we'll show you that here in just a minute. Now, this is the only clause, it's the only clause that can accelerate the work, okay? Change it under changes. Now, what does the clause state? The government can anytime make changes, but must be within the scope. We talked about those four different areas that they can do it, okay? And this can be directed. The contracting officer can tell you, do it, contractor, right? Now, in the end, the government negotiates an equitable adjustment, which includes profit, okay? And a failure to do so, this is what's going to happen. That's basically what that particular clause says. Now, if the government uses this clause, okay, and understand this is for construction now, it's going to be unilateral. It's going to be marked here. They're going to tell you this is the change, okay? Now, if that change is made, the description, and I put it in here, understand why I put this particular clause in here, because of acceleration. If the contractor if the government is going to suspend the work, they're not going to use a changes clause. If they're going to suspend the work, it's got to be the suspension clause in the contract, okay? This would be used for acceleration. So description, details of the change, the new period of performance, the estimated value of the change. The government could put in here, when they direct you, says, this is all that we can give you, okay? So you're going to have to look at that, the not to exceed value. That's the NTE value that may go in there. It could be just an estimate of what the government is basically going to allow. And again, equitable adjustment to be reached. We've got to make sure that language is in there. Now, once it's all said and done, you come back, you tell them this is what that change is going to cost for the acceleration. This is a supplemental agreement. Again, both of you got to agree on it. And this is the description of the specific changes. Again, this is important. Hopefully you get everything that you wanted out of that negotiation, and the contract value is going to change from one value to another. Now let's talk about the termination for convenience to the government. And you see that yellow one, that's 52-249-1. This is a short form that may be in your construction contract. And basically, this particular one is very unique, and it usually it's used for construction under 250,000. Okay, folks. But it says termination for convenience of the government. It can be at any time. The government can terminate that, and they don't have to explain why they terminated. And again, the termination can be all or part of the contract. But let me tell you about this particular clause. The process for the settlement is going to be in accordance with FAR Part 49, okay? And the 49, basically termination of contracts, okay? Termination of contracts basically has the direction to the contracting officer. So let's look at that here very quick. It says compensation is a matter of judgment. It can't be measured exactly. So if you go to FAR Part 49, which gives direction to the contracting officer, this is what it tells the CO. It's a matter of judgment, can't be measured exactly, and it's going to be business judgment. Contracting officer has to use business judgment, and the FAR tells them this is the heart of the settlement. Okay. Now, let's look at the long version of the termination for convenience clause. It's a little bit longer. It's so long I can't put it in here. I'm just going to tell you basically what that clause says. The government can terminate at any time, all or part. The government must provide notice of the extent of the termination and date, advise you to stop work, and place no orders. Okay, they're going to advise you to terminate all subcontracts. The other thing is, and it's very important, they're going to assign the rights and titles and interest under subcontracts. You're going to basically assign it to them. Whoa, what does that mean? Well, basically it means that the contracting officer has determined this particular clause, okay? They're going to have to negotiate with you with some of your subcontractors. And that happens when the subcontractors has a big chunk of the work, okay? Now, you complete the work that's not terminated, and then you submit a termination settlement, and basically this is done like this. Again, they're going to do it unilaterally, all right? Here's the authority, here's the clause, and they're going to give you all that information that I just talked about, okay? They're going to give you directions, what you have to do, because they're going to terminate all or part of the work. Once you submit your proposal, again, like you've seen before, it's going to be a supplemental agreement. You both sign off, and the important thing here, folks, for this termination is, again, the government is going to hopefully make you well, and there'll be, the changes have to be described here, but you've got to be very careful, make sure everything's covered in there. Now, default clause. Oh man, I'm only going to show you paragraph D here. This particular clause basically says, hey, you're going to be in default unless what happens, and I've highlighted those areas. It says epidemics, quarantines, delays of subcontractors, okay? So basically, that particular clause, this is a lot for high-end types of construction, very expensive types of construction, large values. But it gives you this information, epidemics, quarantines, restrictions. Now, the reason I put this out is if the government basically tells you, well, you're not completing the construction contract, blah, 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 and you know, you're delayed, and it's because of quarantines, restrictions, and things of this nature, the thing that you've got to do immediately is tell the contracting officer why it is that this default is coming about, that you cannot perform. And again, it's got to be specifics. You've got to send this information to the contracting officer. Now, if everything goes your way, then they'll probably suspend that work, okay? Hopefully they'll go that route, and we've already talked about how that modification would be made. Okay, now let's talk about Standard Form 33. I've already talked about all of these clauses because all of these clauses are the same ones that I just talked about. You may find them in this Standard Form 33 for, this is called solicitation, offer, and award. This is more for oftentimes non-commercial types of items. In other words, for manufacturing of items or for very complex types of R&D and services. The stop work order basically, and again, this is a very long clause. I'm only showing you paragraph A here, but let me tell you what it says. Again, this applies to services, supplies, and R&D. Does not apply to construction. Okay, now we're talking about this last one here. The government can stop all or part of the work in 90 days. It can be less or it can be more than 90 days, but the government must be specific about what is the work that's stopped, much like the suspension. Must be provided to you in writing. Get it on the Form 30. You got to follow those orders. You know, you got to take reasonable steps to minimize the costs. All of that should be given to you on that Form 30. The other thing is, if the work resumes, the government is going to modify the contract. You know, they're going to give you a change. So let's look at what that would look like. if they're going to use a stop work, again, this is unilateral. Okay, we're talking about the more complex types of acquisitions here. They're going to use stop work, and then what's going to happen here, here's where the details of that stop work is going to be. And let me tell you again, folks, it's so important. You've got to make sure that these details as to what is stopped, you know, what they want you to do with the subs and suppliers, all of that information is in there. If you go to the clause, read it very carefully, because it basically tells the contracting officer also what their responsibility is, okay? Now, once it's all said and done, you come in and you tell the contracting officer, again, it could be, you know, a few months down the road. It's going to be a supplemental agreement. Hopefully you've negotiated, it's bilateral, and here's the negotiated settlement, much like we talked before. Now, I've got some things I got to say here before I open it up for questions, and just some reminders, okay? Familiarize yourself with FAR 4213. Go in there and Google it, and because that's the guidance to the contracting officer. So read it so you'll know what the contracting officer is being told they've got to do when they deal with suspensions, terminations, or stop work, okay? So it's very important you get familiar with that so they don't pull the wool over your eyes. Take no action unless it comes from the CO. Maintain the communications with the CO or their representative, that's okay, but ensure that the direction's coming from the CO. Get all directions in writing, folks. Now, right now I've had some contractors that have told me, I've called the CO, I've sent them emails, I'm not getting anything. Well, I'm sure they're very, very busy, yeah, but you know, they should just keep sending it to them every day if you have to. Call them up, do whatever you need, document all of that, but get the information in writing. If anyone wants to give you verbal direction, especially if they give you the verbal direction, get it in writing from them, okay? The modification, always remember, any changes are legal only a standard form 30. Keep detailed records. This is so important, folks, especially if the work is going to be suspended or there's going to be a stop work. Keep detailed records. You know, you won't get it reimbursed if you can't support it, if you can't demonstrate your losses. In the past, I dealt with contractors who want to tell me, well, I did this happened, you know, and I tell them, you know, woe is you, because you've got to support it. Now, if you notice here, I've got a case here, and I've given you the information at the end again. So there's some cases here that dealt with these types of situations we're having right now and how the courts rule. Reassign your staff if possible. Demonstrate efforts to reduce cost. You can't have your people just standing there going, you know, licking their thumbs here, you know. Now, that may be different. If you've got folks that were working and they all had clearances, it's not easy to let them go, you know, and get them back. So understand, you know, let the contractor know these are some of the issues that you're having to deal with. Advise the CO of issues with your suppliers or subcontractors. If you're having problems with them, you've got to advise them. It's got to be factual again, folks. I've got one contractor that I'm talking to right now that's having major problems with their suppliers, and it's hurting them on getting started. Have a plan. Let me tell you, have a plan if subcontractors or suppliers can't or won't cooperate. Okay, you definitely have to have a plan. And you know, the government's going to be not going to be forgiving. They're going to tell you, oh, what did you do? Did you try to get anybody else? Oh, I never thought about that. Well, you better start thinking about that. Okay. Now, be patient with the COs. They're just as confused as you are right now, I think, with everything that's going on here, folks. Last couple things. Have a plan. CO may ask you for one, especially to restart the work. Advice from others should be backed up. What I mean by that is there's a lot of organizations out there that want to give you the advice. Make sure you back it up. If they tell you, oh, you got to do this, this, and this, and tell them, okay, let me see it. Where did you come up with? Show me the far side. If they tell you, well, I heard that. No, have them back it up. Anybody who gives you advice, have them back it up. All right. Now, those are the last two things. Lynn is going to send you copies of the PowerPoints. And she's also going to, so this will be included, some cases and then some websites that I want you to read to give you more about what's going on in the government with this virus issue. Last, Lynn, this is yours.
Okay, thank you. So before we take questions, I just want to say thank you everyone for being on with us today. If you're a native-owned business and you need any kind of technical assistance, I want to encourage you to reach out to the Acorn Project by visiting our site, nativebiz.org. And if you have any post-webinar questions that you would like to discuss with Mr. Gonzales, if you will go to his website, supplieruniversity.com, and you can click on the contact link on his website and submit your question to him that way. He will be happy to answer them. Again, you know, make sure it's related to this webinar and try to keep it, you know, simple. We're not trying to put Mr. Gonzales to a lot of work, but I know he's always happy to give advice. And as you can see, he's very knowledgeable. So at this time, I think we will go ahead and open it up to questions. So Benny, I don't know if you can see, if you click on the Q&A box down at the bottom, if you can't see the question.
Yeah, hold on a second. Let's see.
It's okay. Let me read the.
No, I really can't. I can't see the Q&A box.
Okay, no worries. So this question is from Lee Velton, and he says, Benny, if the government is going to accelerate the timeline on the construction contract, would they most likely talk to awardee first in case the only way to do it is bringing on more people or working around the clock?
Yes, absolutely, Lee. This is why, you know, if and this is for construction, the other folks that are listening, the acceleration is only for construction. So what will happen, Lee, is they'll have to issue it. Again, if you go back, they'll have to issue a change order, basically telling you that they're going to make a change and they're going to accelerate the work, and it's going to be a unilateral change order. And then what's going to happen is the contractor is going to look at the acceleration details, what they want, and then they're going to come in and they're going to submit a proposal. And there'll be discussions before and after this whole negotiation. And then there'll be a negotiated settlement. There'll be a change to the contract, and the contractor will be on their way to make that that change. Now, one of the things that could happen, Lee, and that's important, the contracting officer can do this one of two ways. They can issue direction to immediately begin acceleration, or they can issue a change order to basically give the contractor maybe a week to submit a proposal, and then they'll negotiate it and then finalize it. So, hey, Lynn, can
yes.
Let me, maybe I just log out of this. Do I escape? I see. Okay, there's more. You did something. You brought down that stuff. Can you do that again? Whatever you did. Did you bring it down? So I can see but okay, let's just go ahead. What's the next question? Lee, did I answer your question?
That was all of the questions that have been submitted. If anyone else would like to ask a question, you're welcome to type it in or raise your hand and I will unmute your phone line so you can talk. Any more questions? Okay. Well,
if you don't have any, if you do have any questions, let me tell you folks, again, go to Supplier University, to that contract. There's a drop down and send me that question. I'm not going to charge anybody unless you want to put me to work. That's another thing. But any questions, I'll be glad to help you out as much as I can. I'm already helping out some other firms on some of the issues that are coming up with them. But I'd be glad to do it. Again, I'm not going to charge you for any advice or because you know, our firms need a lot of help right now. So I want to be able to do my part. And certainly, again, Lynn, thank you so much for what Acorn Project is doing.
Yeah, well, thank you for your time today, Mr. Gonzales, and I will send these webinar slides out to everyone here within the next few minutes. So thank you all very much, and I hope you enjoy the rest of your day.
Okay, thank you.